Hi, Joanne.
Hi, Ben.
So you've had yet another Court of Appeal judgment handed down, a case called Gill and Lees News Limited, and this time it's a 1954 ground A, B, and C case. So let's have a chat about what was decided and what significance the case has to other cases.
Sure.
So, just as a reminder to everyone, ground A, B, and C are referred to as the bad tenant grounds. It's where the landlord opposes the grant of a new tenancy under the 1954 Act because of A, the state of repair of the holding resulting from the tenant's failure to comply with repairing obligations, B, the tenant's persistent delay in paying rent, or C, the tenant's other substantial breaches of obligations of the lease, or for any other reason connected with the tenant's use or management of the holding. And unlike the other grounds, like the redevelopment ground or the own occupation ground, where if the landlord satisfies the requirements of the ground, the court must not grant a new lease. If in these cases the landlord satisfies the factual preconditions, such as there's been a delay in paying rent, the court has to make a value judgment as to whether the tenant ought not to be granted a new tenancy.
This case was about a small corner shop, effectively, not literally on a corner, but a small supermarket. And as the term of the current tenancy was coming to an end, the landlord had served a schedule of dilapidations, and the county court judge found that there was substantial disrepair at the time of that schedule, and indeed at the time that the landlord served its notice in response to the tenant's request for a new tenancy. But in fact, the tenants got on with and dealt with the disrepair so that by the time of the trial, there wasn't substantial disrepair left. And there were two issues that were live in the Court of Appeal. One was, at what date is the court to judge the state of disrepair? And the other is the factors that the court is to take into account when reaching its decision as to whether or not the tenant ought not to have a new tenancy.
Okay, let's dive in with the first of those. So the Court of Appeal had to consider whether a landlord could succeed if there's been disrepair in the past, but the disrepair had been remedied at the time of trial. And Lord Justice Lewison decided that the court wasn't limited to assessing the state of repair or disrepair at the date of trial. Now, he supported that conclusion by reference to various obiter comments made in earlier cases, including Betty's Cafe in the House of Lords, although there were some conflicting things said in those decisions. But he also thought there was no magic in the date of trial, given that the new tenancy would commence sometime thereafter, at least 3 months and 21 days later. But the thinking appears to be that the court can have regard to the tenant's past behaviour, like it can under ground B, without any particular limitation. There's one interesting point, is that on one reading of the decision, there still needs to be disrepair at the date of the landlord's notice. And that's because of the way Lord Justice Lewison puts it. He introduces the issue by presenting it as a choice of relevant date as between the date of the landlord's notice, or section 26(6) counter notice, and the date of the hearing. And he does the same thing when he concludes the issue. He says that it would be too prescriptive to say disrepair at the date of the notice must be ignored. Now, what isn't said is whether disrepair before the date of the notice is relevant. What do you make of that, Joanne?
Well, the landlord's argument was that ground A is engaged if you have disrepair at any time during the period of the tenancy under which the current tenancy holds it. And that argument is not explicitly rejected. And in fact, I think the logic of Lord Justice Lewison's judgment is that disrepair doesn't have to be in existence at the date of the notice any more than it has to be in existence at the date of the trial. It's disrepair at any time is potentially relevant. So that opens up the prospect that potentially you could have a long lease, a 20-year lease, where a tenant has been in breach of its repairing covenants at year 5, but the problems have all been remedied by year 7. And when it comes to year 20, and the court's considering whether or not there should be the grant of a new tenancy, the landlord relies on ground A. Now, obviously, that's a really extreme example, and it's very, very difficult to see how the court would refuse a new tenancy on those grounds. But it does give rise to some interesting questions, and it does seem to me that there is the potential for landlords to rely on breaches of repairing covenants that have been remedied even by the date of the Section 25 or Section 26(6) notice. And then really, you'd get into a question about whether or not the notice has been served in good faith. So it's a valid notice. And that might really come down to, does the landlord really honestly think that there's a chance that the value judgment will be exercised so as to refuse the grant of a new tenancy? It's also relevant to note that, and as Lord Justice Lewison says, that in its terms, ground A doesn't require the disrepair to be substantial. He says that really goes into the value judgment as to whether or not there ought not to be a new tenancy. So it's a powerful factor, clearly, as to whether or not it's substantial, but it is potentially engaged even by quite minor disrepair.
I mean, that point makes you think that there must be a risk now that landlords are going to put ground A in particular oppositions in as a tactical ploy. I mean, in particular, in a straightforward ground F or ground G only case, the automatic statutory compensation scheme applies, so that if the tenant, faced with that opposition, gives in and leaves before it gets to trial, the matter never gets to trial, it still gets compensation. But if the landlord relies upon grounds A to C in addition to ground F or G, then the tenant doesn't get compensation if it quits before getting to trial. So landlords often want to see if they can just about squeeze in an A to C objection, even if their main ground of opposition is F or G. And it seems to me it's going to be easier than ever before for a landlord to do that.
Yeah, we all know that landlords and indeed tenants are prone to gaming the system. So if there's an option available, it may well be taken. I think what tenants might come back with are greater challenges to the validity of notices on the grounds that they've not been served in good faith. And so we might see some litigation around that issue as to what constitutes a valid notice for these purposes. Sure.
Right. Well, what about the other part of the decision, a question about discretion?
Yeah, so that's right. So the other aspect of the decision in the Court of Appeal confirms that the value judgment, whether or not the tenant ought to have a new tenancy, is a very broad one, and lots of factors are potentially relevant to that. The landlord argued that it ought to be approached on the basis of looking at things solely from the perspective of the landlord, and that the court couldn't look at, for example, hardship to the tenant, and the Court of Appeal rejected that argument. The Court of Appeal have also cleared up some uncertainty that had been created by apparently conflicting authorities as to whether or not you take a broad value judgment or you look at things on a very compartmentalised basis. So what was confirmed was that the trial judge was right in the way that he'd approached it, which is what he'd done is he's looked at each ground individually. So here there was A, B, and C, and indeed F, which we can talk about later, relied on. He'd looked at ground A, looked at ground B, looked at ground C, and then he'd stood back and looked at all of them together. And that was confirmed to be the right way to approach the value judgment in this case. And litigation conduct was an issue which was relied upon by the landlord. And what the Court of Appeal have said on that is that it's potentially relevant, but it's a very rare case where litigation conduct alone is going to be the thing that will prevent a tenant getting a new business tenancy.
Okay, so where does this leave us? We put the tagline on this video as clarity on the test. So overall, we're back to a big melting pot test, aren't we? I mean, the court isn't limited in time. It's not limited in nature when it comes to factors that it takes into account under grounds A, B, and C. But we're given precious little guidance as to how the discretion should then in fact be exercised. So there's going to be plenty of room for argument, and I think we can expect to see some more cases of this sort getting to court.
I mentioned that the landlord had relied in his notice on ground F. And there was an interesting debate during the Court of Appeal hearing. It doesn't feature in the judgment, but it is an interesting point. The tenant, faced with a notice which relies both on ground A for disrepair and ground F, reconstruction or demolition, might well say, well, hold on a second, why should I bother putting these premises into repair when you tell me that you're going to reconstruct them or you're going to demolish them? And the tenant here had relied on that point in the county court. The county court judge wasn't particularly impressed with it and thought that it didn't create a particular dilemma. But the Court of Appeal was more interested in the prospect that it did create a real dilemma for a tenant faced with a notice of that nature. And one of the suggestions that was made was that in case management terms, the court might order the ground F challenge to be tried initially as a pre-preliminary issue, as it were, before then going on to consider ground A, so that the tenant would know at the time it faced the ground A challenge whether or not ground F had been cleared out of the way. What do you think of that, Ben?
Oh, these splitting trials up, it's so expensive. It slows matters down so much. So you get months or years of uncertainty. But I was wondering whether the court could draw a line in time when the landlord first tells the tenant that it intends to redevelop. Because before that time, the tenant can really be regarded as being culpable for failures in repair. But after that time, the tenant might be excused, particularly if the tenant confirms that it's going to carry out the necessary works if the ground F objection does in fact fail. And I wonder, I haven't thought this one through, but I wonder whether the court might even look into a conditional order, just like it does when granting relief from forfeiture. You'll get your new lease, provided you do actually carry out these works, but that's all for the future.
Yeah, well, tenants often give an undertaking or can give an undertaking to carry out works. And that seems to me, if the court believes that they're genuine, a good way to resolve these kind of issues. Anyway, Ben, that's been really interesting to talk it over with you. And yeah, more litigation coming our way, I don't doubt.
Nice to chat as ever.